For today's story, we are talking about the ongoing drama facing Ray Andiachero, a YouTube drama channel which is ending its own legal nightmare. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content, and today may be the day I earn your subscription. For today's story, we are dealing with the ongoing drama of Ray Andiachero versus Karen Yax. Ray Andiachero is the mother of a son who died under suspicious circumstances. Some say murder, some say self-harm. It's a little bit in the open air. But Karen Yax thinks that she knows best. She has a podcast and a YouTube channel, and she's trying to contact people all over the place, including, most notably, in the great state of Mississippi, for things related to her content. So Ray Andiachero would like to sue for some of the tortious things that Karen Yax has said. Karen Yax said, I would like to not be sued very much in Mississippi. This is a case of personal jurisdiction. So the question is, did Karen do enough stuff in Mississippi to be dragged before a Mississippi court and potentially receive its judgment? Let's get started with this. In this case, Ray Andiachero is suing Karen Yax for defamation and invasion of privacy. The plaintiff is a mental health provider in Mississippi. The defendant is a true crime internet broadcaster in Michigan. In relevant part, the plaintiff alleges the defendant defamed her in stating that the plaintiff committed bribery and contributed to a patient's self-death. So this is part of the things that were said. Yeah, we've accused Miss Andiachero of all kinds of malfeasance. In her professional capacity, which means it's per se, incidentally, we've accused her of doing such a poor job it led to a patient's self-harm. And we also accused her of bribing others, including by giving beer and alcohol to minors in order to get her story told and things like that. So yeah, we're saying a lot of things that sounds very suspiciously factual to my mind, and we haven't seen great receipts. Karen Yax's idea of receipts are they were in the public domain, in which I beat my head against the wall, as I'm sure some of you guys will remember. Let's see if this court also wants to beat its head against the wall. Now before the court is the motion to dismiss for lack of personal jurisdiction. This will sound very, very familiar to our friends of Without a Crystal Ball and our friends of Toddy Westbrook. Same exact issue. The matter is fully briefed and ready for adjudication. The sole question is whether they've satisfied the familiar test for personal jurisdiction. Having reviewed the arguments against the applicable law, the court finds that they do meet the standard for personal jurisdiction. So yes, this case says that Miss Yax can be sued in Mississippi. Now, as we all well know, in the case of Without a Crystal Ball, we could not find any specific act really that occurred in Washington. You know, it wasn't like she called anyone, interviewed anyone, and to the extent that she viewed sources in Washington, it was just a happenstance along the way because she views sources everywhere. So we didn't find anything specific, and to the extent there was anything specific, it was so de minimis as to not matter. So the question is, did Miss Yax do more than that? Well, let's find out. The court seems to think so. Let's find out if they're right. First, Mississippi's statute is satisfied because the injuries occurred in the state. Well, that's not enough. If the injury occurs in the state, then under the statute, tort is committed at least in part in the state, and per se jurisdiction is conferred upon Mississippi court. Yeah, no, that's too broad. Just because you have the tort there, you have to show causality by the defendant. Second, the plaintiff must establish personal jurisdiction as consistent with due process. So it sounds to me like Mississippi statutes goes further than the federal law, which is not a thing you can do. But at least we satisfied it for Mississippi. When only specific jurisdiction has been invoked, this is the legal standard. Did defendant have minimum contacts with the forum state, purposefully directing its activity towards the forum state, or purposely availing itself of the privilege of conducting activities in that state? Did the defendant's cause of action arise out of or result from these contacts? So is there a causal factor? Did you get injured because of the plaintiff, what they did in the state? Or defendant, what they did in the state? Would exercise of jurisdiction be reasonable and fair? Procedurally, the party invoking jurisdiction bears the burden of establishing the sufficient minimum contacts. Yes, jurisdiction must be proven by the plaintiff. when the court rules on a motion to dismiss for lack of jurisdiction without holding a hearing. However, the non-moving party need make only a prima facie showing, and the court must accept as true non-movers' allegations result all factual disputes in their favor. So when there's not a hearing, as is true here, you need to only show the prima facie case. So it's not much. You just have to show that you have enough that, if true, would show it to be true. Have you shown enough that, if true, would lead to sufficient minimum contacts? Under this relatively forgiving standard, it is relatively forgiving, all things considered, the plaintiff has indeed made a prima facie case. A review of the available communications suggests defendant intentionally and purposefully wished her words to impact the plaintiff in Mississippi. These are the minimum contacts defendant herself creates within the forum state. Okay. So she wished her words into Mississippi. So the idea is that she directed them into Mississippi, which again was not true for Without a Crystal Ball. She didn't direct her words into Washington. She just put them onto a YouTube channel for anyone to watch. So she didn't really direct anything into Washington. This court says that she did. All right, so let's find out. In this circuit, when a non-resident defendant commits a tort within the state or an act outside the state that causes tortious injury within the state, the tortious conduct amounts to sufficient minimum contacts with the state by a defendant to constitutionally permit courts within the state, including federal courts, to exercise personal adjudicative jurisdiction over the tortfeasor and causes actions arising out of its offenses or quasi-offenses. Even an act done outside the state that has consequences or effects within the state will suffice as a basis for jurisdiction in a suit arising from those consequences if the effects are seriously harmful and were intended to or highly likely to flow from the conduct. So again, we're showing some intentionality here by the defendant. They're meaning to bring this on in that place. The court says that is the case here. Under circumstances, it would neither be unreasonable nor unfair for the defendant to litigate in Mississippi, and the brunt of the harm is experienced here under Calder. The defendant presses several arguments for dismissal. She contends that her audience is likely minimal, and damages in Mississippi were not significant. Even so, at least one of the communications at issues seems intentionally directed towards the plaintiff herself. And because the plaintiff has alleged defamation per se, the question of limited or mitigated damages is ill-suited for adjudication. So whether or not those damages amount to much doesn't preclude the case from being heard. The defendant then argues Michigan would be a more convenient forum in which to litigate. That's probably true for her. The legal standard regarding venue, though, applies a more robust multi-factor test, taking into consideration the burdens and benefits of venue to both the parties, not just movement. Fifth Circuit precedent says the plaintiff's choice of venue is entitled to deference. Reviewing these factors, the court is not persuaded. Defendant has met their burden to prove that Michigan is clearly more convenient. So yeah, plaintiff gets their choice if multiple options are available. For you to win over that, you have to show that one choice is clearly superior. And it's not clearly superior. In fact, if anything, it favors the jurisdiction in Mississippi because the people that would be testifying against you, the people that you communicate with, are in Mississippi. So to the extent there are specific facts, they seem to go against your interests. Lastly, defendant argues that any resulting judgment will not be enforceable in Michigan, which will leave the plaintiff without recourse. But that is a risk the plaintiff has elected to take in filing the suit here. She will continue to bear that risk. So whether or not any judgment is enforceable in Michigan or not is an issue for the plaintiff, right? Maybe it won't be. I mean, I can't think of any obvious reason it won't be, but maybe, right? So maybe she'll get a judgment in Mississippi and it won't be enforceable in Michigan. If that's the case, then sucks to be the plaintiff, though, but that's their choice. So it's no harm to you. Can you elaborate as to no recourse? It just means that she can't enact her judgment. That's what it would mean, right? So she gets a judgment from Mississippi, and what Karen is saying is that's unenforceable in Michigan. So it's worthless. It's worthless is what she's saying. So you have no recourse. You have no remedy, right? So yeah, you have this piece of paper, but you have no way to enforce it, so you have no remedy. The defendant has presented other arguments regarding jurisdiction. Those not specifically addressed above would not have changed the outcome of this order. That said, the court emphasizes the present legal standard requires all factual disputes to be resolved in the non-movement's favor. The defendant reserves her right to renew her motion with appropriate evidence at a later juncture, so as the evidence develops. The motion is denied and all other motions are moot. Within 10 days, the parties shall contact the chambers of the magistrate judge to schedule a telephonic conference. It is an all right decision, but the court's reasoning is a little thin for my taste and a little conclusory. There were specific acts and specific facts that would have allowed the court to reach this conclusion, but it didn't really point to those specific facts. It just made a very conclusory statement of law. So while this answer might be okay, it might even be wrong. And the court doesn't go through the factual analysis to show the factual underpinning. They just kind of say it as a matter of fact. They don't point to specific allegations or specific statements they think show the purposeful availment. They just kind of refer to it obliquely. So it's a little bit thin in the analysis. It may be correct, but at least for the moment, that brings us to the end of consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.